Welcome, and thank you for joining us for our recorded panel on the ins and outs of the North Carolina Department of Justice's Public Assistance Section, particularly involving Medicaid recipient appeals. I am Kayla Britt, an Assistant Attorney General and the North Carolina Bar Association's YLD's Law Student Division Director. Today I have with us two assistant AGs who are currently practicing in the area of public assistance, and I will take a moment to allow them to introduce themselves. Ellen, would you start?
Good afternoon. I'm Ellen Newby. I'm a Special Deputy Attorney General, and I have been with the AG's office since October of 2007. I have been in the public assistance section that entire time.
All right, Erin?
Good afternoon. I'm Erin Hucka. I'm also an Assistant Attorney General for the state of North Carolina, where I represent the North Carolina Department of Health and Human Services. I graduated from the University of Massachusetts Law School. I practiced as a prosecutor in the greater Boston area for a short time before relocating here in North Carolina. Once I was here, I started at the AG's office representing the North Carolina Industrial Commission. I made my way to the Health and Human Services section, where I represented Medicaid and recipient appeals, which is what we'll be discussing today, for about 4 years. Currently, I do still represent Medicaid, but I handle provider appeals.
All right, thank you. So we're just going to go ahead and jump into the questions. Ellen, I specifically want to start with you. Tell us a little bit about what the function of the public assistance section is, specifically regarding Medicaid appeals.
Well, in general, the Attorney General's office represents state agencies. And as Erin said, our particular state agency is the Department of Health and Human Services. That's our client. And mainly, particularly with related to Medicaid appeals for the recipients, the client is a subsection, Division of Health Benefits. That is the Medicaid state agency. The Department of Health and Human Services is the single state agency that administers the Medicaid program, and the Division of Health Benefits is that subsection that really controls Medicaid. And so very simply, when a Medicaid beneficiary, someone who is already on Medicaid, they're not fighting about eligibility, but if they make a request for a service, product, or procedure, or if they are already getting a service or product and that is reduced or terminated, and they're not approved for what they requested, then they have the right to appeal that. And so primarily what we're doing is defending those decisions to deny, reduce, terminate, or suspend services or products and procedures. And often what that means in defending cases is settling them. Very frequently, we're getting new information. We are explaining things to the best of our ability without providing legal advice. We're helping people understand what the rules are so that they know whether they qualify or not. And very frequently, it's a matter of missing medical information. And so a lot of times we're receiving information and providing it to our client for review, providing legal advice. If we can't resolve it, we do have a hearing at the Office of Administrative Hearings, and any appeals from those cases go to Superior Court and on after that.
All right, thank you. Erin, did you have anything to add to that?
I do not.
Okay, so Erin, why don't you explain the day in the life of an AAG in your section? How does this vary, or does it vary based on years of experience or based on the day? Tell us a little bit about that.
Sure. Days vary depending on caseload. Sometimes it's a little bit of a roller coaster. Sometimes you have a really heavy caseload, and other times you're just kind of like waiting for that roller coaster to happen. And I do think that the caseload is also dependent on experience. Some days you'll spend all day reaching out to petitioners. Most of our petitioners and recipient appeals are pro se, which can sometimes make it challenging depending on the petitioner. Sometimes you get very challenging petitioners, some very passionate petitioners, and other times after you explain something to them, they're like, oh, okay, and they understand. In those calls, when you reach out to a pro se petitioner, as the attorney for Medicaid, I usually explain the denial, the termination, or reduction. I explain their options going forward. I explain what legally will occur and answer any questions that they might have, as Ellen said, without giving any legal advice. Some other days are spent drafting motions for cases that qualify for motions like summary judgment or dismissal, among other types of motions. Other days are spent preparing for trial. As Ellen touched on, sometimes our cases will go to a full hearing, which is pretty much a trial. So during those times when preparing, you have to make sure that your witnesses are prepared to testify, that they understand what's going to happen, and that that you kind of prep them to foresee anything that's going to happen during cross-examination. Other days, you'll get a massive amount of documentation from petitioners or opposing counsel if there is one, and you'll look at those documents, send them to your client. Some days are spent reviewing the initial documents for new cases. And like I said, I do think that this varies depending on experience. I do think that the more experienced attorneys get harder cases. With recipient appeals, that would mean things like private duty nursing, a program that we have for disabled children and disabled adults, whereas some of the newer attorneys get, I would say, kind of easier cases such as in-home aid, denials, or terminations.
Okay, Ellen, you have anything to add?
I think I just want to add to what Erin said. We purposely give the more complicated cases to the attorneys who are more experienced and have been here longer in service to the client. And a lot of what Erin was talking about was our daily litigation schedule, and that is primarily what we do. But also, we sometimes provide legal advice and legal research to the client. Sometimes they'll ask a question, and it'll be up to us to find some legal advice. Additionally, we also provide advice on policies and other things like that. So sometimes we're doing still work for the client, but non-litigation in addition to the litigation. It is primarily litigation, but there are other pieces as well.
All right. Are there any special projects that y'all are assigned to work on throughout the year aside from criminal briefs?
Yeah, so we also handle what's called petitions for judicial review, which are almost like an appeal at a superior court level, and they can encompass anything from somebody appealing their denial of eligibility for Medicaid or food stamps. It could vary from many different things. So we do special projects for the client as well.
Thank you. Erin, what other parties does your job require you to communicate with?
So like I touched on before, in recipient appeals, most of the time our petitioners are pro se. However, occasionally there will be a opposing counsel on the other side. So we do definitely have to communicate with pro se individuals as well as opposing counsel. And when our cases happen, we usually have some type of expert witnesses. In a lot of cases, it's usually two of those expert witnesses. One is qualified as an expert in the relevant Medicaid policy, and the other is qualified as some type of medical expert. Like I was saying earlier, sometimes if we're doing a private duty nursing, we'll have a nursing expert, or if there's a dental case, we'll have a dentist. So our experts vary depending on the type of case that we're handling. And I think, Ellen, I'm not sure if you had anything to add to that.
Sure. Well, again, Erin is primarily talking about the litigation, which is a huge part of our job. So, of course, we're dealing with the parties, mostly pro se, and of course, judges. For OAH, for Medicaid appeals, there is one administrative law judge at the Office of Administrative Hearings who is designed to handle the vast majority of our cases. And I was actually on the phone with her shortly before this meeting about some cases. So the judge is a key person. And Erin mentioned petitions for judicial review, PJRs. Then, of course, you're dealing with those appeals and judges in Superior Court and on. We also often deal with legal advocates as part of advice to our clients. Our client gets interaction from stakeholders, people receiving the services, medical experts, providers, and like I said, the advocates. Sometimes we will talk with them, particularly when providing advice about policy and procedures. Very often, Erin mentioned, people are pro se, they don't have attorneys, but under federal law, you are able to designate anyone you want to be a representative and to help you with your case. So we will deal with whoever they designate as representatives. Often it's a family member or a friend, but very frequently it's also the provider of services. So we are frequently dealing with Medicaid providers who sometimes are medical professionals, as Erin said, and sometimes not. And they often have varying degrees of experience and understanding in what the policy for that particular service requires, because Medicaid has clinical coverage policies for its services and when clinically Medicaid will cover these services and when it's determined to be medically necessary. Of course, we are dealing with the client all the time, but the client has a variety of different, it's a massive group, lots of different individuals. Some of the people at the client are the medical experts that Erin was talking about, nurses, doctors, physical therapists, pharmacists, and sometimes those folks are more leaning towards management. They're not the clinical piece. So we're dealing with those. And we may even deal with lobbyists or things like that in certain meetings and advice.
Okay, well, Ellen, we're going to stick with you. As the supervisor, can you tell us what the requirements are to get to be hired as an assistant attorney general in this section?
Well, it really depends on what positions we have open and what's available. And as I said, I've been here since 2007 in this section. And so there have been a variety of different options. In general, for the AG's office, there are usually positions open, and it just depends on what qualifications. Currently, our section does not have any temp or attorney one positions. Those would be the kind of positions that would be straight out of law school, which is exactly what happened with me. I was hired with 2 other attorneys for a temporary position. It was qualified as essentially an attorney one position, which would require no previous legal experience. We were supposed to be 3 to 6, maybe 9 months at most, temporary positions. Obviously, since it's over 16 years later, that didn't happen. And one of my colleagues that I was hired with was in the general counsel's office at our client, the Department of Health and Human Services, for some years. But that can vary. It just depends on what's available and what those, what the qualifications are. And very frequently, people will apply multiple times to get their foot in the door. And then once you're in the Attorney General's office, you're sort of a known quantity, and it can be easier to take other jobs because you're internal.
So, Ellen, since you don't have attorney ones or temporary positions, that would mean that it's unlikely for a law student to be hired directly out of law school?
That would be correct, unless they have some legal experience that they could. Generally, an attorney two requires at least 1 year of experience as a licensed attorney. And so typically we don't have entry-level positions unless, like I said, there are temporary positions. I think both Erin and I started with the DOJ in temporary positions. Our current section head started as a temporary, and I have worked with numerous attorneys who were temporary with us or with other positions in the DOJ before they got made permanent. So that is a very common way to get in if that's an option. So outside of temp positions, like I said, attorney ones, but very often the DOJ is looking for people with 1 or 2 years experience to start.
Okay. And what experience would you advise someone to get if they are specifically interested in doing Medicaid recipient appeals?
Well, if someone is specifically interested in what we're doing, we look at a variety of different things. Of course, it always looks good to clerk for judges because that's impressive, but that doesn't always lead to the kind of experience that we have. So we look for people who have experience dealing with pro se folks. That is a big part of our cases. Like Erin said, the vast majority do not have attorneys. If you have experience with anything medical or Medicaid, that can be very helpful. I actually worked in a lab in college, and then in law school did some work, before my 3L for a firm that involved medical. So I never intended to fall into Medicaid and have my legal practice involve looking at medical records, but here we are. So that can be very helpful if you have some background in either medical. For example, we had someone who, before they came an attorney, had worked for the state in medical billing. That was sort of helpful when looking at medical records. We also look for people who have a similar population. Just as an example, my husband has nothing to do with state government, but he does insurance, and he works for the company that does market of last resort. And without divulging any confidential information, we have a lot of the same kind of conversations with folks where, some of the folks that are on Medicaid are going to be, dealing with some of the things, same kind of population. If you have worked in any sort of legal field where you're dealing with a lot of folks who may be, because we're dealing with the Medicaid population, and there is a huge variety of with the people in there, but they are on Medicaid. So there is some sort of hardship, medical issue, and often they don't have the resources, the education to afford a lawyer. They may not have the background to understand. It can be very scary if someone from the Attorney General's office calls you about a lawsuit. We hear from people, well, I didn't want to go to court. I don't want to make a big deal. I don't want to talk to the judge, that sort of thing. So if there's any population that you have dealt with, evictions or things like that, that would be a similar population, that can be helpful. And then also litigation skills. I know it can be really hard because everybody wants to see that experience, but sometimes, like Erin, as an ADA, has some litigation skills. She's not the only ADA we've hired. So it really just depends. And also a dedication to working for the state. There is no guarantee, the salaries are not huge. And so there has to be some passion there to really want to do a good job. One of my former supervisors said part of our job is to do good government. And that's what we want to see in some of the people that apply.
Absolutely. Can you speak on internships or externships? Do y'all typically have those in your section?
Yes, the AG's office in general has internships and externships, and it is an application process that's general to the Attorney General's office. My understanding it is that it's assigned, but it can be based on preference. So if that's something that folks are interested in, that would be, and we definitely have summer internships for law students, and they are often placed in our section, gives people an opportunity to do whatever we have to do, come to court. We had an attorney who argued a brief in the Court of Appeals. I complimented their brief, and they said it was a law student that helped write that brief. So when we have cases, we will take the law students to the Office of Administrative Hearings with us so they can meet our administrative law judge, see how a case looks, things like that. And that is, it just depends, what's available. Like I said, we almost always have one every summer. But it is not like private practice. So it's not a direct line to employment. They're more internships and externships are more for experience and awareness. It would be a good opportunity to see not just the section you're working with, but potentially other sections to see if you're interested in the Attorney General's office and what section you might be interested in. And of course, it always depends on, after your internship, what positions are open. We are state government. We're required to post and interview for positions. There's a minimum number of interviews. We can't simply hire people without going through that process. So, the internship is not a direct line, but it is an opportunity to make a good impression, and it certainly can be beneficial. I have personally hired people who have interned with the AG's office, some directly with us and some not. And even an internship not with us can set you up to have a good word. When we see an application from someone who has worked at the AG's office or someone who has interned, then we know we have a trusted person within the AG's office to get a good, fair recommendation from. So any internships, like I said, while they don't relate to direct positions, they can position someone better to have an opportunity when positions come available.
Thank you. Erin, what is something that you wish law students or young lawyers understood about your job?
So I just kind of wanted to touch on a little bit of stuff that Ellen said first, if you don't mind. I also started as temp, and I know that she indicated that. But I also had a lot of experience with pro se people as an assistant district attorney. And then when I did start as a temp representing the North Carolina Industrial Commission, a big majority of my cases, the petitioner was also pro se. So I think that my experience with pro se people was really, really helpful in me getting my foot in the door in health and human services. Not only that, but I think that because I had a litigation experience, I think that also helped. So I just generally, just to kind of reiterate what Ellen said, I do think that getting your foot in the door, whether it's through an internship and then going to get some experience, or getting a temp position is a great way to start. A lot of us here at the AG's office, as Ellen said, started that way. And it's a good way to get your foot in the door, network a little bit, and kind of find out where you want to go from there. So I just kind of wanted to reiterate that because I think that's really important, especially when, as a law student, you hear, oh, well, we don't hire right out of law school. Well, there are ways around that, like the temp positions, internships, getting as much experience as you can, depending on what section you want to go in. So I just wanted to touch on that. Something that I wish students or young lawyers understood about my job is, as somebody who prefers litigation, I think handling recipient appeals, or really anything in the Health and Human Services section, is a good balance between litigation and legal writing. And when it comes to legal writing, a lot of the issues that we run into have happened in the past, or something similar has happened in the past. So you don't really need to reinvent the wheel. There's always somebody to reach out to get answers from, or bounce ideas off of. So I don't want people to think that, coming to the AG's office, like you're on your own representing your client. You're not. You have a great group of people and support and resources.
I want to go back to the experience real quick. Don't discount pro bono experiences at your law school. I had a criminal appellate background, and when I interviewed, I was able to rely on a lot of my pro bono experiences for working with pro se people and working with certain populations of people. So that is something that you can do while you're in law school or while you are in your first year of practice to kind of build up your resume. Ellen, did you want to add anything about what you wish law students and young lawyers knew about your job?
Oh, yes, thank you. But I do think that's a good point, that pro bono work is another great way to get experience, and particularly the type of experience that might translate well to public assistance, and particularly the recipient appeals. I just want to say that litigation is mostly not in court. If you're an ADA, maybe that's an exception, but a lot of what we do is talk to people over the phone, beg them for medical records, remind them to get medical records, and then talk to our client about their medical records. It's really nothing like TV, as much as I wish it were. So don't, and that's more for the non-lawyers. A lot of our petitioners think they're going to talk to the judge for 5 minutes and they're going to get what they want. And they don't know that it is an evidentiary process, and it does require medical experts, medical testimony, medical records, because ultimately Medicaid is looking to approve what is medically necessary and approvable under law and policy.
So we talked a little bit about what kind of jobs that new lawyers might receive in the section. Can we go into a little bit more detail about personal care services and ortho, so that the audience kind of understands on a basic level what you actually do?
Sure. And we have 2 attorneys that started earlier this month, and those are their primary cases to start off with. So the first one is personal care services. And in general, Medicaid covers a list of, it's basically an insurance company for people who qualify. And so but we have our clinical coverage policies that are posted online. There are medical experts involved in writing those. And one of our biggest services is personal care services. It's a program to provide a little bit of basic hands-on assistance with the main 5 activities of daily living: bathing, dressing, toileting, mobility, and eating. And so in order to qualify, and this is actually set forth by law, not by clinical coverage policy, which is a little unusual, but in order to qualify, you need to require hands-on assistance with at least 3 of those 5 activities at a limited level, or extensive assistance with 1 activity of daily living and at least limited or greater with at least 1 other. So the way we manage this is our client contracts with a vendor who sends out a nurse to go to a person's residence, do an assessment, and that is done annually. It's done when you first request it, the service, to see if you qualify. And then afterwards, it's done annually to see what you're still qualifying for. Most people are eligible for up to 80 hours. So what happens is A request is made, that was a request for an assessment to be assessed for personal care services. And then the assessment, assuming everything works out, the assessment is done. And at any point, if there is a denial, reduction, termination, or suspension, that person will get a letter in the mail that tells them a bunch of things, but specifically that something is being denied, reduced, or terminated, what that is, what policy, law, regulation requires it, and how to appeal. And so say if someone made an initial request for personal care services, we did the assessment, they were able to demonstrate that they could do all of those 5 activities of daily living, bathing, dressing, toileting, eating, and mobility without hands-on assistance, they're going to get a denial letter. That denial letter is a few pages and it comes with a blank appeal form. And it's a very simple process. It's actually governed by law, and that law is North Carolina General Statute 108A, 70.9 A and B, and that sets forth the rules for these kind of appeals. And so very simply, it also has rules on these adverse decisions that we're talking about, this letter telling someone that they're not going to get what they asked for, what they were previously getting. So if someone is denied personal care services, they fill out that form. It's 1 page. It matches, it gives the Medicaid ID, so we know who it is. It has the date, the service. There's also an option to call in and provide that number. They call the Office of Administrative Hearings, provide the information on the form. And there's a complicated technological system, but basically, once that appeal comes in, it's matched to the decision. And the first step is mediation. Medicaid will have the appropriate medical professional, doctor, nurse, usually nurse or pharmacist or dentist, depending on what's appropriate, participate in mediation. We, the attorneys, don't get involved unless the petitioner has an attorney or there's something unusual about the case. And roughly 80% of our cases settle at mediation. I think that's a really important piece of information. We're not involved, like I said, in most of those. So very often people get a denial or they get a reduction, and of course they appeal. It's not hard to do. And then they're not really understanding. And so they get that opportunity to talk to some sort of medical expert, to ask questions, to find out, what's denied, what the rules are, that sort of thing. If mediation is unsuccessful for any reason, it moves forward to hearing, and that's when we get involved. So for this personal care, for PCS, we're looking at the assessment that the nurse did. That's our primary document. And it's about 15 pages. And it's very, sort of simple with information about who lives in the home, what the individual, what the nurse saw when the individual was demonstrating those 5 activities, what level of assistance the nurse judged them to need. And then it's a comparison to policy. It's sort of almost like an algorithm, basically, that will say, yes, you qualify, and how many hours? No, you don't. And so our job is very simply to defend that decision. The due process rules are, apply to Medicaid, both eligibility and these service appeals. There is a Supreme Court case called Goldberg versus Kelly, which made due process apply to Medicaid beneficiaries and sets some of the rules and gives these options. And so this is why we're sort of going through this process. Every state has set that up differently. But basically, when we have a hearing, what we're doing directly is getting the assessment, getting the decision, getting the policy, seeing if there's any medical records, and preparing for the hearing. We're preparing to defend that assessment. But the assessment is a snapshot. The nurse comes out once a year for an hour. We know it's not perfect. And we also know medical things can change. What someone can demonstrate for the nurse in the morning, maybe they can't do in the afternoon. Unfortunately, like I said, there's a variety of backgrounds and resources. Not everybody is capable of articulating what they need for themselves. Also, these are folks on Medicaid, and when we're at personal care services, there does have to be a medical condition or diagnosis that causes the need. It's not just normal, age-appropriate behavior. So a lot of people are basically saying, I need more help. You took away my hours or you denied me hours. And we're trying to figure out, okay, do you need help? And is it the kind of help that translates to personal care services? So a lot of times people need help with cleaning their house, doing the laundry. We understand that, but is that Medicaid? Ultimately, Medicaid is insurance. We're providing medical assistance. So cleaning your house, by law, housekeeping is not part of personal care services, but that's very difficult for people who are pro se to understand. We'll hear things like, but my neighbor gets it, this, that, or the other. So it's a matter of explaining to someone, it's based on this assessment, it's based on this policy, this is what the nurse saw, please get us medical records. Very often that's what happens. People will get us some medical records and they'll help show, not that the nurse did anything wrong, but there are some conditions, circumstances, diagnoses that led to this person needing more assistance than what we were able to understand in that brief visit. Other times, once people see the policy, once they see the assessment the nurse has done, and once they see what's allowed, they realize they don't qualify or they don't qualify for as many hours as they thought they wanted, and they'll withdraw. When we can't reach an agreement, that's when it goes to hearing. And we very carefully send our exhibits in advance because Medicaid beneficiaries have the right to examine their documents at a reasonable amount of time in advance. So our current practice is about 3 weeks in advance. We'll often call people to warn them that we're going to send the documents and let them know, this for personal care services, the basis is this assessment when the nurse came out and had you do your demonstrations. We'll tell people to get us medical records if they don't agree with it. We'll often make another phone call and, once they've gotten our documents and ask them about it. Sometimes we have to prompt them to read it. I had one person, and we send our documents either via UPS, trackable mail, or certified mail, USPS, so that we know they've gotten them. I had one person tell me she didn't open her certified mail. She put it away on the shelf because she was afraid of it. So I had to assure her that there's nothing to be afraid of, but you do need to look at these because, we're going to have a hearing on that. And so there's a lot of work that's education, but again, being very careful not to provide legal advice. I have practiced the phrase, I'm the attorney for Medicaid, so I can't give you any legal advice, but I can try and answer your questions. So that's a fine line to walk. And then the administrative law judge, we have had the same judge for over 13 years. And so that's helpful as well to have someone who understands Medicaid, because there is a lot of federal law about how complicated the program is, and how no one wants to toil in these minefields, because it is very complicated with Medicaid to have federal law, federal code, state law, state code, clinical coverage policies, and then of course, medically necessary. What is medically necessary? And that's going to vary. So that's personal care services. The other basic thing are braces.
Before you go to ortho,
Sure.
When you have a beneficiary whose services have been terminated or reduced, do their services stop immediately?
That is a great question. And I want to sort of preface this all by saying what we're talking about is Medicaid Direct and fee for service. That's sort of the same terminology. There has been a push towards Medicaid transformation that you may have heard about. And that is where there are prepaid health plans that are responsible for basically managing the services, for doing the prior approvals. And when I say prior approvals, most of our services, you have to request in advance and get prior approval. And that's frequently what we're fighting about. Someone has requested prior approval for personal care service and it's been denied, reduced, or terminated. So I wanted to give that caveat because there are different laws in the prepaid health plans. It's called managed care in the managed care world. But everything we're talking about is fee for service, Medicaid Direct. And so those, you get what's called maintenance of service. If you were receiving a continuing service, you'd previously been approved for a certain number of hours personal care. As long as you appeal timely, you get to keep your services until the appeal is resolved. So a timely appeal is 30 days. So as long as you get that one-page form or you call into OAH, as long as you get that in within 30 days, then you get, and you do have to remain eligible for Medicaid. If you lose your Medicaid eligibility, that's a different issue. But you do get to maintain your services. It basically preserves the status quo. And that makes everybody very happy because it gives you a little bit of breathing room. If somebody needs a continuance, they're not going to lose their services immediately. And so that's helpful. If they file their appeal late, they don't get maintenance of service. And technically there is no jurisdiction. And so we would move to dismiss, but we always try and settle the case anyway, just because they can reapply at any time, which is a very important piece of information. It's sort of unusual and different to a lot of lawsuits. If you drop your appeal, you're done. Here, if you've applied and it's been denied, you can simply make a new request. Now, if nothing has changed, they're going to deny it again. But obviously with medicine and with evidence, things can change. Maybe we needed information from a medical professional that they hadn't seen or couldn't get the records from, which is a great segue to orthodontia, braces, basically, which is another thing that Medicaid covers. We have a policy. We're looking for functionally impairing condition. Basically, something that is causing something in the condition of your mouth that could be fixed by braces that is causing some sort of functional problem, a problem with chewing, eating, speaking, it's causing pain, it's causing problems with hygiene, that sort of thing. Very often people will tell us that their child has some sort of mental health issues related, they're being teased about the condition of their teeth. We would say, we can take that into consideration, but we do need information from the appropriate medical professional, appropriate mental health professional in this case, to document what is the problem with the teeth. And a lot of times that's a situation where families don't have that, they can't get it, so they'll withdraw and they might reapply in the future and provide that information if it's applicable. Braces, generally what happens is there's a request submitted by the orthodontist. Our orthodontist, and this is again similar to personal care services, our client contracts with a vendor who has dentists and orthodontists and staff. They review it. There are specific documents that are required, so we have the medical records. And the policy criteria is pretty broad. What we are looking for is basically they have a list of criteria, and if you meet 2 or more, we almost certainly know you're going to have a functional condition, so a functional impairment, so you're very likely to be approved. But even if not, there's a very important piece of federal law that's called EPSDT, Early Periodic Screening, Diagnostic, and Treatment. And it applies to Medicaid individuals who are under 21. And it basically requires that Medicaid provide the services that would otherwise be available under Medicaid, regardless of policy limits, to children if those services are medically necessary. You do have to be medical in nature. They can't be experimental. But for example, personal care services is usually capped out at 80 hours. But for children, there is no cap if it's medically necessary under EPSDT. Similarly, with braces, we have this criteria. Even if you don't meet criteria, we're going to look, is there anything else? Again, we're looking for a functional impairment, because if it's not functional, it's not going to be medically necessary. Medicaid does not cover cosmetic treatment. It is not medically necessary. But what we're looking at in these cases is models and x-rays, as well as the narrative. And that's a big difference with personal care services, because we're looking at very specific medical records, and you're looking at measurements on the teeth. How far is a part of the spacing? How far apart are your front teeth from your back teeth when you're biting down? Is that a problem? Is that not? So those are good, great illustrations of both the easier type of cases, but the wide variety of medical necessity. Under personal care services policy, we're really looking, do you meet that policy criteria? It may be medically necessary that you need assistance with bathing, but if you don't need assistance with any of the other activities, if you need bathing but not mobility, dressing, eating, or toileting, we're not going to be able to approve you because that's the criteria. On the other hand, with braces, because of that rule under EPSDT, but just in general, what the policy is describing is essentially any time we would expect braces to be medically necessary. And that also highlights the difference between, the concrete medical measurements and what is documented in the medical records versus trying to decide if someone is able to bathe or toilet themselves, which is highly variable and not as easy to quantify as compared to, measurements in a mouth.
So can you very briefly tell us whether your job has been affected by Medicaid expansion?
It has been affected by Medicaid expansion in that we have fewer of certain types of appeals. We seem to have more in other types of appeals, and some of that is also related to COVID. Thank you.
All right, Erin, we're gonna go back to something I mentioned earlier about criminal appeals. So it is my understanding that you are required to complete criminal appellate briefs as a civil division employee. Can you tell us a little bit more about that?
Sure. Every permanent attorney in the civil division at the AG's office is required to complete a number of criminal appellate briefs. Most of the attorneys are assigned 4 criminal briefs to complete per year. This is in addition to completing your day-to-day tasks of your position. However, I think that 4 number varies Some attorneys are only required to complete 2 per year, and that's all dependent on the contract that the AG's office has with the client. So for instance, our client is the Department of Health and Human Services, so it's dependent on what the contract says between the AG's office and the Department of Health and Human Services.
So are these criminal briefs in any way related to the work that you do?
No, unfortunately not. However, I think a lot of people learned from them. You're researching law that you may not have not seen before, not dealt with before. So it's kind of like a whole new thing. So it is a little bit challenging at first as somebody who doesn't really like to write legally and who didn't have any experience handling criminal appellate briefs. However, I think over the years, you're like, oh, I've dealt with this issue. I've briefed this issue. I have a brief on this, and I think it expands your skill set.
And do you know why Civil Division is required to handle these briefs?
Ellen, I'm not sure if you'd like to answer that.
My understanding is that North Carolina, unlike every other state, when there is an appeal of a conviction in Superior District Court, that those appeals to the Court of Appeals are simply handled by the AG's office instead of the district attorney's office where they arose from. We do have a criminal section and they do handle some of the more complicated and difficult briefs, but we simply don't have the staff at the AG's office or in the way it's arranged to have that section handle all of the appeals. So like Aaron said, our contract with the Department of Health and Human Services, everybody is funded differently depending on their client, but our contract funded by the client only allows us to do 2 per year.
Okay. Well, that is all for the questions that I had prepared for you all. Is there anything that you would like to add, keeping in mind that law students and young lawyers are our audience?
I just want to encourage everyone to try and find a job either with the AG's office or anywhere else that speaks to what you're interested in, because your legal career is going to be long. So you want to have at least some interest or passion in what you're doing, however that is, whether you like the subject, you like your coworkers, you like the environment, maybe you like the pay, but find something that helps you get through your day to day.
I'm going to ask one last follow-up question. So what characteristics in an employee in this section do you find to be most successful?
That is a wonderful question. Attention to detail, dedication to the job, and an ability to deal with a number of different types of people while still maintaining, zealous representation of your client.
And I just wanted to add to that I do think that the newer attorneys that come in, sometimes some of their downfalls are, oh, I can handle this, I got this, and they will, reinvent the wheel. So I do think that it's very important for newer attorneys to ask all of the questions to the more experienced attorneys, get an idea of what's happened in the past, and use that to gain knowledge and handle this just like our client would want us and expect us to handle it.
All right. Well, thank you both for being here with us today. If we happen to have a law student or a young lawyer who is interested in reaching out to either of you, would it be okay for me to share your email addresses?
Absolutely.
Okay. All right. Well, thank you both for being here. Thank you to the audience for watching this recorded panel, and we will be back soon with a different section.
Thank you.
Thank you.